What's your emergency? 911, what's your emergency?
Be advised, Car 4 has control of the pursuit. Proceed with caution.
Hello, everyone, and welcome to Behind the Crime Door. How are you guys tonight? Hi, Lynn. Hi, Olivia. Good to see you. Hey, country girl. Welcome, welcome. I know a lot of people are live right now, so I'm just going to give it a few minutes, just a couple. I know that Steve from True Crime Web is ending pretty soon, and some people will be coming over from there. And hey, Serendipity, how are you? I have a really bad cold, you guys. I was trying to decide if I was even going to come on live. Yeah, that's my baby. That's Finn. He's really wanting my attention right now, and I'm not giving it to him. So he's been kind of bugging me about that. But I was live this morning after what happened in the court room today. And I thought, well, I'm going to go ahead and try to go live tonight, just for all of my regular subscribers who are so supportive of me and my channel that are here on Tuesdays, Thursdays, and Saturdays for me. So, because I don't normally go live during the day, but I did have quite a few people today, so that was kind of nice. Hey, Sees Through, how are you? Hey, Lisa. So good to see you. Hey, Cheryl Devine. Thank you so much. I do too. My daughter called me today when she got off work, and she's like, "How are you?" And she said, "You sound awful." And I'm like, "I do when I feel awful." So I'm just kind of hanging in there. I'm going to try and sleep after this live and see how much I can sleep tomorrow. And then maybe tomorrow night I'll feel better and I can start doing some of my prep for Thursday. Hey, Jill. How are you? Hey, Rob Lee. How are you? Hey, Never Silent. Thank you for being here. Hey, Danger Dave. Welcome, my dear. Love to see you guys. Hi, Will. Hi, Aussie Issy. How are you? Hey, Verbal Judo. How are you? It's good to see you guys. I know, I do. I'm looking forward to it. I'm looking so much forward to the time with my family. Hey, Jennifer. I'm so looking forward to that. There's going to be about 25 of us for Thanksgiving. So I just enjoy that family time. We play games and do all kinds of fun stuff. So I'm looking forward to it. I did some work today, a little bit on a couple of other cases. I was doing some investigating stuff on a couple of other cases that we've been talking about, and then I made a couple of videos that I put out there. And so if you guys haven't got a chance to take a look at those, we are going to watch one of them here in just a minute that I put out because I think it's really important. And especially after everything that happened this morning. And with a lot of the comments that I've been getting, a lot of the questions, people are confused about some things. And I just want to kind of help possibly set those things straight, maybe give people a little bit more knowledge than they had before they came in tonight about some certain legal documents and how things work in the court. Oh, Freckle Joy, I hope you enjoy yourself. I am such a traditional person when it comes to the holidays. I am so traditional that I absolutely hate when people say, well, why don't we try to do this different this year when it comes to recipes? I'm one of those people that I want my grandmother's recipes that my grandmother made for me when I was growing up and that my mother made for me when I was growing up. And that's the way I want things. I'm really lucky because my extended family all feel the same way. So yeah, it's it's interesting. But there's times when you just have to do things different. So I hear you on that. I hope you enjoy it. Thanks, Verbal Judo. I'm glad that you do. Okay, so what I'm going to do is I'm going to present my video that I made on the probable cause document. I am going to have to stop it periodically because what I did when I made it is I didn't give enough transition time between the slides, so it's hard to read them. So I'm going to be stopping it and reading them. So let me share my screen with you guys. And this is to educate everyone on what the probable cause document is. So what is the probable cause affidavit? The probable cause affidavit is a summary of the evidence and circumstances of the arrest. It is written by the arresting officer and given to a judge to review. And normally what happens is that the arresting officer puts the information in the affidavit and then presents it to the prosecutor. The prosecutor will then tell them whether or not they feel that there's enough probable cause for an arrest. If they feel there's enough probable cause, then the prosecutor will in turn take the document to the court and present it to the court to have a ruling on whether there is enough probable cause. And the judge will say yes or no. And if they say yes, then an arrest warrant is issued for that person or persons. Hey, Steve, welcome. So good to see you. Thank you so much for being here. So why do they write a probable cause affidavit? A probable cause affidavit is required when an officer makes a warrantless arrest, which is when the officer arrests someone without getting permission from a judge first. Typically, an officer sees someone break the law and immediately arrests the person. After the suspect is brought to the jail, the police officer writes up the probable cause affidavit, swears that it is true, and then gives it to a judge for review. The judge makes sure that there was sufficient evidence or probable cause to arrest the person. This is done to make sure the police aren't just arresting people for no reason. I disagree with some of the claims made on the probable cause affidavit. What can I do? This question is coming from the defendant. The only thing that can be done at this point is to fight the case in court. It should be noted that the probable cause affidavit is not evidence itself. It is only a summary of what the officer claims the evidence is. There is more to the story than what is on the probable cause affidavit. How do I get my side of the story to the judge? The probable cause affidavit won't include everything about the situation, just the basics of why the officer thinks you broke the law. The officer also writes a more detailed description of the arrest in the offense report. This is the narrative that the prosecutors will review. The offense report typically includes much more information than the probable cause affidavit. We are not entitled to a copy of the offense report until much later in the process, usually 2 months or so. We will convey any additional information about the incident to the prosecutors. A warrant may have been issued for the arrest on the probable cause. Can I get them to release the warrant? No, unless we have incontrovertible proof that you are completely innocent, such as a video that proves you didn't do it. The police officer will not change his or her mind based on your version of the events. They will tell us to talk to the prosecutors in court. Are probable cause documents public documents? Probable cause affidavits are public documents. They can, however, be sealed if the court deems it necessary to protect a case. So if for anyone out there saying it's against the law for them to do this, it absolutely is not. Can I get a copy of the offense report? Not immediately, and only through your attorney. Offense reports are not public documents. They are considered work product of law enforcement. Eventually, your attorney will be able to get a copy, but not for 2 months or so after the arrest. The probable cause affidavit is a summary of the allegations against you. It is the document used by the judge to set your bond. The following is an example of a state statute on affidavit of probable cause. Issuance of warrant or summons, availability of supporting affidavit or testimony. If the magistrate finds from the complaint or from an affidavit or affidavits filed with the complaint or from other evidence that there is probable cause to believe both that a crime has been committed and that the defendant has committed it, a warrant for the arrest of the defendant shall issue. What is a probable cause affidavit in Indiana? The prosecutor can submit a probable cause affidavit to a judge asking for an arrest warrant to be issued if he believes the probable cause exists that the suspect or suspects committed the offense. An affidavit is a written statement of facts that the affiant person making the statement swears to be true. An affidavit typically requires a signature and usually includes language acknowledging that the affiant is open to prosecution for perjury if any assertions within the document are not true. Often, for the affidavit to be legally valid, the affiant must swear to the statement in front of an authorized person, like a notary or county clerk. Affidavits can come into play in all kinds of cases, not just criminal ones. Establishing probable cause. The Fourth Amendment the Fourth Amendment doesn't define probable cause. It's clear, though, that an affidavit a police officer submits to a judge when applying for a warrant has to identify objectively suspicious activities. It cannot simply recite the officer's subjective beliefs. An affidavit has to establish more than a bare suspicion that criminal activity is afoot, but it doesn't have to show proof beyond a reasonable doubt. In general, when deciding whether to issue a search warrant, a judge or a magistrate may well consider information in an affidavit reliable if it comes from any of these sources. Sorry, guys. Both can do it. Verbal. The law enforcement officer can do it as well as the prosecutor. Normal circumstances are the law enforcement officers, the investigators within a case, come across the probable cause that this person they believe committed whatever said crime happened. They then in turn write up the probable cause document and they take it to the prosecutor and they show it to him or to her and they say, this is our evidence that we believe shows that there's probable cause this person committed said crime. The prosecutor will review that affidavit and any substantial additional information besides the probable cause. In other words, they're going to look at the evidence. Even though the evidence may not be completely, and most often is never completely written into probable cause. And once he or she believes that there is probable cause, then it is them who take it to the court to have a judge or a magistrate rule on it if there is probable cause to order a warrant for an arrest. Oops. Sorry, guys. Gotta go back. Let's see if I can do this. A confidential police informant whose past reliability has been established or who has firsthand knowledge of illegal goings-on, an informant who implicates himself or herself as well. Hang on a second. Did I miss something? I think I did. Hold on. I did. Okay, no, I'm fine. Sorry. I got out of sync. I apologize, you guys. So this is how they establish the probable cause. They either use a confidential police informant whose past reliability has been established or who has firsthand knowledge of illegal goings-on, an informant who implicates himself or herself as well as the suspect, an informant whose information appears to be correct after at least partial verification by police, a victim of a crime related to the search, a witness to the crime related to the search, or another police officer. For example, hoping to obtain a warrant to search Olive Martini's backyard, a police officer submits an affidavit to a magistrate. The affidavit states that the undersigned is informed that Olive operates an illegal still in her backyard. The magistrate should not issue a search warrant based on this affidavit because the affidavit is too vague, and the source of the information is unstated. There's no way for the magistrate to evaluate its reliability. The affidavit doesn't establish probable cause. Here is the example with the same case. The affidavit states, I am a social acquaintance of Olive Martini. On 3 occasions in the past 2 weeks, I have attended parties at Martini's house. On each occasion, I've personally observed Martini serving alcohol from a still in Martini's backyard. I have personally tasted the drink and know it to be alcoholic. I had no connection to the police when I attended these parties, and this affidavit is reliable enough to establish probable cause for issuance of a warrant authorizing the police to search Martini's backyard. The affidavit provides detailed firsthand information from an ordinary witness without police connections that indicates criminal activity is taking place. I will say to my mods, any of you that are getting ready to leave, please check the Discord mod channel because I left you guys a message. Thank you, and everyone have a great Thanksgiving. I will not be here on Thursday or Saturday. If you happen to be arrested, detained, and charged, then there is most likely a probable cause or a physical evidence that points to you. Which type of evidence is overlooked the most? Footwear and tire evidence is the most overlooked evidence in the forensic sciences. Yet every perpetrator must get to the crime scene in some manner, whether it be from walking, driving a vehicle, or riding a bike. The potential of footwear or tire evidence being at the crime scene is significant. Why is it important to determine probable cause? Courts usually find probable cause when there is a reasonable basis for believing that a crime may have been committed for an arrest, or when evidence of the crime is present in the place to be searched for a search. Under exigent circumstances, probable cause can also justify a warrantless search or seizure. Which of the following can be used to establish probable cause? An affidavit signed by a law enforcement officer usually accompanies the complaint. The affidavit explains the crime committed as well as the role of the accused in that crime. In other words, the affidavit is used to establish probable cause that the accused actually committed the crime. So, that was what I put together this afternoon to help people understand what the probable cause is all about. And there's many places that you can go to look for this, but the Justice Department has great resources about probable cause. And probable cause is the legal grounds on which a law enforcement officer can conduct a search, seizure of property, or arrest someone. Probable cause is the reasonable belief by a law enforcement officer that an individual is committing a crime, has committed a crime, or will commit a crime. And it is based solely on facts. There are 4 types of evidence that can establish probable cause. Observational evidence, things an officer sees, hears, or smells at possible crime scene. Circumstantial evidence, a set of facts that when put together suggests a crime was committed. Circumstantial evidence is different from direct evidence and needs to be supplemented by another type of evidence. Officer expertise. Officers skilled in certain aspects of law enforcement may be able to read a scene and determine whether a crime has occurred. And evidence from information. This includes information gathered from police, radio calls, witnesses, or confidential informants. The Supreme Court has stated that the concept depends on the context and is very imprecise. The court has often opted for a more flexible stance on probable cause in cases with more serious charges. The Fourth Amendment of the United States Constitution protects individuals from searches and seizures by government officials deemed unreasonable under the law. And the search and seizures at an individual's home are considered unreasonable without a warrant. However, there are times a warrantless search is lawful if the officer gets consent to search the home. A lawful arrest of the individual has been made in the immediate area. The officer has probable cause to search the area, or the items in question are in plain view. An officer may briefly stop a suspicious individual and ask them questions to relieve their suspicions if the officer observes conduct that makes them reasonably believe that a crime will occur or has occurred. A warrant is not needed before searching a student under a school's care and authority. The search must be reasonable under all circumstances of law. Searching for cars. An officer has probable cause to stop a vehicle if they believe that a car has evidence of criminal activity. They are authorized to search any area of the car evidence can be found. They have reasonable suspicion that a traffic violation or crime has occurred. An officer can pat down the occupants of a car during a lawful traffic stop and have narcotic detention dogs walk around the exterior of the car without reasonable suspicion. Law enforcement has a special concern. They are authorized to make highway stops without reasonable suspicion. Routine searches at border stops, sobriety checkpoints to combat drunk driving, and stops to ask motorists about a recent crime that has happened on that highway. And the probable cause affidavit, as we just learned, is written by the arresting officer and given to a judge to review. The affidavit summarizes the evidence and the circumstances leading to the arrest. It also contains witness accounts or information from police informants. A probable cause affidavit is written when an officer makes an arrest without a signed warrant from a judge. Cases of warrantless arrest usually occur when officers see someone breaking the law and arrest them at the scene. In determining whether there was probable cause for a search, seizure, or arrest, the court must find that under the same circumstances, a mentally competent individual would think a crime was being committed. This procedure is done to make sure police aren't arresting people without reason. When an officer announces that they are placing an individual under arrest and they restrain them, they must have probable cause to believe that that person committed a crime. Generally, the amount of evidence needed to establish probable cause is more than a suspicion that a crime was committed, but less information than needed to prove guilt beyond a reasonable doubt. If an officer were to arrest someone without probable cause, the individual may file a civil lawsuit. Usually, the individual will state they were falsely arrested or prosecuted maliciously. The court will not proceed with the lawsuit if the officer was simply mistaken. A probable cause hearing is a preliminary hearing that takes place after charges have been filed against an individual. This happened October the 28th for Richard Matthew Allen. The court hears witness and officer testimony to determine the likelihood that the defendant committed the crime. If the court finds there is probable cause, the case will move forward to trial. A probable cause hearing can also refer to a court proceeding that determines whether an officer had a valid reason to arrest an individual. And this hearing determines whether law enforcement can continue to hold a defendant who hasn't posted bail or hasn't been released on their own recognizance. This type of hearing occurs in conjunction with the individual's arraignment or first appearance before the judge. There is a very well-known Supreme Court case involving probable cause, and it is Terry versus Ohio from 1968. In this case, a detective watched two men walk along the same route in alternate directions, pause at the same store window, and then continue on their routes. This happened 24 times during his observation. At the end of their routes, the two men spoke with each other and during one conference, a third man joined them briefly before quickly taking off. Using observational evidence, the detective came to the conclusion that the men were planning to rob that store. The detective followed the two men and watched as they met up with the third man a few blocks away. The detective went up to the men and announced himself as a law enforcement official, and after hearing the men mumble something, the detective completed pat-downs of all three men. Two of the men were carrying handguns, and ultimately the three men were arrested. The courts noted that the detective had probable cause to stop and frisk the three men because they were acting suspiciously. The detective also had the right to pat down the men for his own protection, as he had reasonable suspicion to believe that they were armed. The Supreme Court dismissed the appeal of the case because there was no constitutional question involved. Reasonable suspicion is used in the various contexts of criminal law involving search and seizure. It's a legal standard that requires a law enforcement officer have an objective, articulable reason for suspecting an individual is involved in criminal activity. Essentially, it's the step before probable cause. Officers can only briefly detain an individual based on reasonable suspicion. Reasonable suspicion can be thought of as a justifiable hunch, whereas probable cause is actually and only based on evidence of criminal activity. Probable cause requires stronger evidence than reasonable suspicion. And at this point of probable cause, it is obvious that a crime has been committed. Additionally, aside from an officer, any reasonable person looking at the circumstances would also suspect the individual of being involved in criminal activities. So, what are the key takeaways from all of this? Key takeaways are probable cause is the legal grounds on which a law enforcement officer can conduct a search, seizure, or arrest. Reasonable suspicion requires an officer to have an objective reason for believing someone has committed or will commit a crime. For probable cause, it is obvious to an officer or to any reasonable person that a crime has been committed and the individual may have been a part of it. If an officer arrests someone without a warrant, they will have to write a probable cause affidavit, submit it to a judge, and attend a hearing to determine whether the arrest was legitimate. So how does this all play out, and how does this all work around what's going on with the Delphi case and Richard Matthew Allen? Well, let's take a look at what happened this morning in court. We know that there is a probable cause affidavit that has been sealed by the request of the prosecution in this case. They told us when they announced his arrest that the reason for this was because it would be detrimental to the investigation that was ongoing if this document was released and the information were to get out into the public. We now know today, by what was said in court, that there are numerous witnesses and that some of these witnesses are minors, which means they're still children. The court definitely wants to protect any child witness, always. They want to protect them from harassment by media, YouTubers, anyone on social media that may try to reach out to them to get statements or interviews, or podcasters trying to get them on their shows. The same with any of the witnesses. Right after court ended this morning, Nick McClellan put in a request to the court And the order was to have, hold on one second. There's been so much activity. Where's it at? The motion was filed almost immediately after the hearing this morning was over, ordering, prohibiting the parties, the council, law enforcement officials, court personnel, the coroner, and family members from disseminating information or releasing any extrajudicial statements by means of public communication filed. I heard a lot of people today say that that's a gag order. Maybe it is. But they don't want a lot of information getting out in the public domain right now on this case. And there's a number of good, solid reasons for that. Everyone seems to wrongfully believe that we as the public have a right to know. We all have a right to know when a case goes to court and goes to trial. We have a right to know what's going on. We don't have a right to know every single thing that goes on in the court, however. And that is why judges will seal records and not allow certain things in the public domain in all sorts of cases, not just criminal cases. Many people have this strange idea that we are entitled to this information. And I'm sorry, but we aren't. Richard Allen is entitled to it, and Richard Allen heard it on October 28th when he went to court. He knows exactly why he's there, because it would have been read to him and they would have told him. So everything that we witnessed this morning by his defense, when they were all being interviewed by media, was all their job. Their job is to defend him and to prove nothing. They don't have to prove him innocent. They don't have to say anything. But they have to appear and give him a good defense. So, of course, they're going to come out and say that the probable cause affidavit is flimsy, that the probable cause affidavit doesn't make any sense, that if we were to look at it, we would say the same thing. Why is this guy behind bars? Give me a break. Come on, let's be realistic here. And go back. We just had a class on probable cause. That's not how it works. The law is absolutely clear so that people know it's not perfect. And yes, people have been wrongly accused. Let's get that out there before everybody starts attacking and saying, well, this is an innocent guy and they're railroading him. I don't believe that for one moment. When they took this man into court, they knew beyond whatever they have as evidence that they had enough. Hey, Deb, how are you? Welcome, my dear. That they had enough probable cause for this man to be behind bars for the murder of Abby and Libby. They had enough probable cause that not only Nick McClellan believed it, but he said, wow, this is enough. We're ready to go to the judge. And he took it to the judge. And the judge looked at it and actually bonded him out at $20 million. That is a huge bond, you guys. That is not something that you see or hear. He had a $20 million bond. Do you think for 1 minute that a court is going to grant a $20 million bond on somebody on flimsy charges or flimsy evidence? It's ridiculous. It's just ridiculous to think that. So that's the first thing. And then the second thing is, after he was charged with the murder charges, they removed the bond, and he is now being held without bond because in the state of Indiana, there's no bond for murder. That's the way it's supposed to be. So why is his defense asking for that, knowing he's been charged with murder, is beyond me. But that's part of their job. Part of their job is to get him out of jail and to get him out of jail as fast as they can. But guess what? The judge this morning kind of slapped him on the hands and said, okay, I'll grant you a hearing for your bail for your client, but I'm not going to grant it until February 17th of 2023. Now, do you think for 1 minute, if she thought an innocent man was sitting behind bars and being railroaded, that she would have allowed that to happen? Do you not believe that she would have had a bond hearing for him in the very near future and allowed them to argue why, both sides, because they both get to, the prosecution as well as the defense get to argue why there should be a bond and why there shouldn't be a bond? Still, he's being held on murder charges, and in the state of Indiana, the law is clear. They don't have bondable murder in the state of Indiana. I don't look for this guy to get out. So, I mean, that's just my opinion. I know it seems unfair, but I wouldn't, when you've got somebody that's been charged with a double homicide of children, especially, I'm sorry, they belong, for their own safety, they belong in jail. He can't be protected if he's allowed out of jail on his own cognizant. He can't. I don't care where he goes. Everybody knows who he is now. He would have to go into hiding, and they're not going to let that happen. They're not. He could flee. There's all kinds of things. He could hurt himself. He could hurt other people. I mean, there's just so many things that could happen here. And all of that has to be taken into consideration. What do I want to see happen? I want to see the best defense ever. I want to see the best prosecution ever, because I want a case that is airtight, that cannot be overturned on appeal. And I believe in our justice system, and I do believe innocent until proven guilty. But I definitely believe that these investigators, in my mind, we're going to find out that Jerry Holman is the one who wrote that probable cause affidavit. I would absolutely be shocked if it was not him. And he was in court this morning. And so I'm thinking that we need to step back for just a couple of minutes and seriously think of this and why things were said. Was there mistakes made this morning? In my opinion, yeah. I don't know and still cannot imagine why a prosecutor would go into court and stand before a court of law on a case that he hasn't even begun to try yet and state that there's someone else out there that's possibly intertwined in this case. Another actor, whatever the heck that means. That just blows this case up for the defense to be all over that. And guaranteed they're going to be. I thought it was quite interesting when Richard Allen's older defense attorney, and I apologize because I don't have his name in front of me. I think I do right here. Hold on. Let me look it up. Let's see. Andrew Baldwin. So Andrew Baldwin was interviewed today after court, and he said a lot. He said some things that just really shocked me too. He admitted that he'd only been on the case for 6 days, that he knew very little about the case. He spent no time with the accused, very little. He said that he was not aware of who Kegan Kline was, and that he knows, like I said, very little about this case. So he's got a lot of reading to do. 6 years worth of discovery coming at him, coming his way. This case will not be in court. I don't even look for it before the end of 2024 and possibly 2025. From my experience with how these cases work and speaking to my good friend, the judge. So, I mean, that's kind of how I feel about that. There was just a lot. He said that his client looked him in the eyes and told him he was innocent. Really? How many people who are being charged with the crime admit they're guilty? People who work with criminals in jail and in prison will tell you, especially those who are working on their appeals, they didn't do the crime. They didn't do the original crime that they are being charged with and serving time for and are being appealed for. So, I mean, I just think that that's interesting that he would say that. Like that was going to be some big revelation to us that he denied doing this crime. No, he's not going to admit to it. If he was going to do that, he'd have done it a long time ago. The other thing that gets me is that he said they asked about his family and who was in court for him today. Nobody said his wife was there, but there were 2 older women. So I don't know if his mother, a friend, I don't know who these people are. But he did say that his wife is supporting him and that she is afraid and that she had to leave the house and now she's back. That she loves her husband very much. They were high school sweethearts and he loves her and they've been together for 30 years. And I know people want to know, how can she still stand by this guy? Well, just like the people that are out here online already defending him and saying that he has been unjustly accused because they can't see the probable cause affidavit. That's how. And yeah, if I was drug into prison or to court or whatever and charged with crimes like this, of course I would be saying I was innocent. Of course I would be, screaming at the rafters or whatever to help me. But we're just going to have to see. Like I said, we have to be patient. We have to wait and see. I am absolutely confident that this prosecution and this investigatory team has what they need, and we don't know what it is. And we have no idea what it is that they have against this man. But I guarantee you, you guys, it's not flimsy. Now, is it going to be easy? No, it's not, for all the reasons that we've talked about. This is not going to be a slam dunk case. This case has been all over the place, all over the board for years. You know, very funny, Truth Seeker. You're right. You are so right. But I do think that what's going to be hard for people and hard for all of us covering this case is that we're not going to hear information when we think we need to have it. We're going to have to wait for it to come out. And I agree, Ivy Rose. You know, I so agree with you. It's not weird to me that his wife is still standing behind him, because I don't believe she sees him as this person. She doesn't know what the evidence against him is. And she's never, ever experienced this side of this man. Hey, Angela Patrick, thank you so much. I appreciate you. Oh, thank you so much. I did get a little rowdy this morning, didn't I? I had some interesting people in here this morning. So, yeah. But yeah, Ivy Rose, I do so agree with you on why she doesn't see it yet. And Jim, I agree with you. I am confident in this judge. She seems to be on ball. I'm glad that she's taking her time and that she didn't make a snap decision today. She's going to look at everything. She's going to look at everything that was presented to her today, all the written documentation that was presented, and she's going to go look at case law. My judge friend said that is standard. That's what she should do. When things are unprecedented, you don't want to just on a whim make a decision. And since it's not precedented in Indiana to have a probable cause document sealed, she's going to need to look at some case law to help her out. WTHR TV reported tonight at 6 o'clock that, oh, my nose is itching. They reported tonight at 6 o'clock that she said that her order will be given or granted within the next 10 days. Do I think it's going to happen sooner than later? I hope so. And the reason being is when there's a void of information, we've talked about it before, people are going to start making all kinds of assumptions, and we're going to have the people that believe in conspiracy theories crawl out of the woodwork, and it's going to just muddy this case and make it a mess. So thank you, Never Silent. You are so nice. So, you know, you have to, it's hard to put yourself in certain positions and imagine what you would do. And one of the things that bothers me is when people do that or say that, and they're like, well, if it was me, I would do this. Or if it was me, I would do that. And honestly, until you're actually in that position, you do not know how you're going to react. You can only assume how you're going to react. I think that if you put these investigators around a table and Doug Carter with them and Nick McClellan with them, sorry, and we ask them questions about what this case has meant to them and how do they feel about this prosecution coming up, I'm sure that they would tell you that this case has nearly broke them. Every one of them. Emotionally, absolutely consumed them. And I just, I like I said, my heart goes out to them because they have given up so much of their time with their families, holidays, over the last 5.5, nearly 6 years on this case. And they don't want to blow it. They don't want to see the wrong person convicted. I said it before and I'll say it again. If they wanted that, they would have convicted Ron Logan. The man's dead. They would have said it was him, put a bow on it, and put it to bed. That's not what they want to do. That is not what this investigatory team is about. And I'm really getting tired of people saying it is. I know that there are, and we've talked about this too before, that there are a lot of law enforcement officers out there that have been in the news, that have done bad things. It's like that in any profession. I have to take a cough drop. Hold on, guys. It's like that with any profession. You're going to have good apples and bad apples. And to try to just say that these guys are, completely the Keystone Cops, they aren't by any sense of the word. And I respect what they do. Have they made mistakes? Of course they have. They're human. This came out of nowhere and it shocked everyone. It shocked me. It shocked you guys. And all of us are still reeling from that because we didn't have any idea who this guy was, not on anyone's radar. Again, it goes back to that hill that I've talked to you guys all about. Are you going to march up that hill and die on that hill with your POI and your theory? Is that what you're going to do? Hey, Hoosier, how are you? Because if you are, you're making this case about you and not about justice and not about Abby and Libby. This case isn't about us. It's not about our POI. It's not about our theory and whether or not we're right or wrong. It's not. And the sooner people realize that and own up to it, the better off we're going to all be in this true crime genre on YouTube, because it's just, there's just not that many. There's evil in this world, but I do believe, especially nowadays, the men and women who decide to become law enforcement officers or court officers of the court, they do not have it easy. It is not an easy job to do. It is a dangerous job to do. And they get ridiculed every single day. Every single day they're ridiculed. Who would choose to do that? But yeah, was I anxious to see an arrest in this case? Yeah. Thanks, Heather. I feel the same way. You know, I'm not going to judge this guy until I see what they have against him. All I'm going to say is I back law enforcement 100%. And if law enforcement tells me they've got enough and the judge said they have enough and the judge set a $20 million bond, yeah, I'm going to believe them. I'm sorry. I'm believing them over us because we don't know nothing. It's like I tried to say today, this morning when I was on my little rant. We don't know anything about this guy. We know none of the evidence that they have against him. But people are presuming they do, and people are pretending they do. And what is so upsetting, can you imagine being Becky Patty sitting there at her computer and watching these people defend this man who's been arrested for her grandmother or for her granddaughter and her granddaughter's best friend's murder? Because that's what it is, you guys. Oh, Truth Seeker, thank you so much. CD's a great guy. He really is. And I really like him. I know this is going to be a long, drawn out time, you guys. It's going to be frustrating for all of us. We're all going to have to just take a step back and take a deep breath and try not to run and jump off the cliff. As GonZo is my dear friend is always telling me, you've got to keep it tight and trust the process. The last thing we want is what happened in the Suzanne Morphew case. I do not want to see that happen. I've seen people defending him and say, yes, Ivy, saying that a wrongful man has been thrown in a cage with no evidence being put out there as to why, and that it's against the law and it shouldn't be happening. And it's not how our court system works. Even though he is innocent until proven guilty, this is how the system has to work. It has to work this way. And quite frankly, I'm not comfortable with anyone that has been charged with double homicide getting released on their own recognizance. I don't know anybody that would, and especially the deaths of 2 children. And Jim, I agree with you. It has taken a toll on all of us. Those of us that have been here since day one, and those of us who have really connected with Abby and Livy and the families especially, it's hard. It's like an emotional roller coaster. Hey, Melissa, how are you? Yeah, no, Ivy, they're out there. They're saying there's no evidence or that it's super flimsy, and there's just no way now that they, his defense is going to say that. Everything I heard from his defense attorneys today, I expected. Nothing that they said shocked me. Nothing. But boy, people, even the media ran with it. I mean, I can't tell you how many YouTube things there are from national media and regional media and state and local media out there right now that have their headline, their byline as Richard Allen's attorneys say not guilty. Wrong guy. They have the wrong guy. That's what they're supposed to be doing. If he was paying them, that is exactly what he would be paying them to do. That is exactly what he would be paying them to say. And the state is paying them. So they are getting paid. Yeah, I think it's quite interesting as well, Ivy, that they did. That is the truth. They usually want to keep as much away from the public as they can. But I think because one of the things I learned while researching all the public or the probable cause document stuff this afternoon is that when they write probable cause documents, very similarly to the way they write warrants, they put the least amount of information in there that they can because they don't want to give away everything that they have right away. They want that to come out during the actual discovery of evidence for his legal team. They don't want it in the public domain. They don't put that information into the public domain for a lot of reasons. To protect the witnesses. And as they say, to protect the integrity of the case. And when you go to law school, you learn that. You learn about the integrity of cases and how and what you have to do to protect them. And sometimes you have to do things and request things from the court that's not going to be in the ring of public opinion's approval. And I just feel like right now we all need to give a kudos to those that have fought hard for Abby and Libby, and who have stood by the families, championing for the justice for the girls, because they're just, everything that's happening right now is supposed to be happening. This is not anything unusual. I didn't expect any huge information to happen today. I honestly didn't. I didn't think for 1 minute they were going to go into court and that document was going to be unsealed today. I just didn't believe that was going to happen. I do believe it will be unsealed eventually. Whether she unseals it within the next 10 days, I don't know. I hope so that it doesn't create any more chaos of people saying that he's being wrongly accused. And I know that when Doug Carter was asked about it in his interviews in the past few days, he said that we will learn a lot from the probable cause document. It's going to answer quite a bit of things for us. Not everything, of course, but it's going to tell us quite a bit. And like I said, I just tend to side with Becky and all of them because this is about their loved ones. Anna, all the Williamses, the Pattys, the Germans. This is about their loved ones. It's not about us. And if they want this stuff kept out of the public domain for now, then who am I to say that we shouldn't have that happen? Carter believes that it should be unsealed, which is a good thing. Because to me, that means right there that he's not afraid for us to see it. He doesn't believe that is some sort of a flimsy document that doesn't have any bearing. Not confusing to me at all, Ivy Rose. I don't believe it. I believe that the law enforcement officers that probably wrote that document, I don't believe that they necessarily want it to be completely out there. I think that there's probably things in it that they want redacted. Like I said, we're dealing with children. We're dealing with children that are witnesses. And does that mean that when they put out the information in December and asked for anyone who had dealings with the Anthony Shots profile to come forward, did they have people come forward in relationship to Ricky Allen? We don't know. We have no way of knowing any of that. That stuff may not have anything to do with Ricky Allen at all. We may find out that, and that if there is someone else involved, it may not be the Kleins. No, Melissa, the lawyer said he told him he's innocent. So no, I don't believe that. I don't believe he's admitted to anything. And as far as what we heard immediately after his arrest, he wasn't cooperating with police at all. Doug Carter is very confident. And I am holding on to that because that man hasn't been confident for over 5.5 years. And so to see him and see his smiles and to know that he feels they got the guy, Tobe feels they got the guy. All you have to do is listen to what Tobe said at the press conference when they announced the arrest to know that Tobe feels they got him. Those things are reassuring to me. And that's how I continue to hold on to my faith. So I really think that that's where it's going to go from here. And we're just going to have to wait. This case will not be back in court until February the 17th, which ironically is 4 days after the 6th anniversary. I don't think any of us would have imagined that. Thank you, Tattooed Girl. I appreciate you for saying that. I have felt that way from day one, and I will always cover any true crime case in that way. This isn't about us. It's about them. It's about Abby and Libby and them getting justice. And it's about the family members that have been left behind with this humongous hole and this massive grief that they're living through every single day. And having to face that man in court today could not have been easy. And I know that they asked Becky as she was walking out of court what she thought, and she said that everything happened today as she expected. It was what was expected. So they didn't expect anything different than what happened today in court. They're also being very careful about what they say about Richard Allen, which we all need to be because he's innocent until proven guilty. And they're reserving judgment until they see the evidence. Because they don't know. They don't know any more than we do. And they want to know as bad as we do. I saw him get out of that truck today, or that van, over and over again, as I was playing it, as I was making my videos, and I was listening to them talk, and I just kept seeing that, and I'm just like, man, what eyes. I thought it from day one when I first saw his photograph, but his eyes just seem so scary to me. Just really scary. Mike said it well after the arrest press conference. He said, we've been searching all these years. Now we've come to the arrest. And now we have to start up the other hill. This is not over. They have a huge, daunting hill in front of them because there's going to be a lot of court dates there's going to be a lot, once they actually get the case started and the trial actually started, it's going to be very difficult for them to hear what happened to their lovely girls. I hope to God, Heather, nothing gets leaked. I truly hope nothing gets leaked. As far as whether or not we will learn things before February, I do believe we will. I most certainly do believe that we will. That's just my opinion. I don't know for sure, but I believe we will. There was one other thing I wanted to tell you guys. Hold on a second. We were talking earlier this week about, I'm trying to get my ducks in a row here, guys. There we go. Trying to get those out of there. And we were talking about what's been going on in Idaho with the co-eds that were killed. And I just wanted to go over something with you about what I found. I found this information today as I was looking for other stuff, which is usually what happens for me. But it's been a week since they were found stabbed at the University of Idaho. And they have an FBI profiler who has spoken out about this. And his name is, he's former FBI profiler Jem Clemente. And I have seen him on crime shows. And I've also seen him on Fox News, CNN, places like that, MSNBC, where he's talked before about forensics cases. And this is what he had to say. The suspect behind the unsolved murders of the 4 University of Idaho students earlier this month was likely someone who knew the victims or a stalker who was familiar with their habits, one of the nation's foremost criminal profilers hypothesized on Tuesday. Tuesday marked 9 days since the co-eds were discovered stabbed to death inside their Moscow, Idaho home. As of Sunday, local, state, and federal law enforcement had received 646 tips in the week since November 13th, but they are still searching for the person or people who were behind it. He killed 4 different people this way. He didn't just sort of blanch and run after the first one, former FBI profiler Jem Clemente said. He's a retired FBI supervisory special agent and a criminal behavioral analysis expert. He told Fox News he believed the suspect was likely a young man who has not carried out such violent crimes before. He's sloppy, Clemente said, when reached by phone on Tuesday. This is probably more of a compulsive kind of person that would put him at a younger age and maybe in the age group or just above the victims. I don't think he's particularly sophisticated, criminally sophisticated, or forensically sophisticated, he added. The killer's decision to comment or to commit such a brazen crime was indicative of his relationship with one or more of the victims, Clemente hypothesized. Going into an occupied dwelling with 6 people in different rooms in the middle of the night is an extremely high-risk crime unless he knows one or more of the people, the former New York City prosecutor said. So that is my first thought on it. This offender did not just randomly choose this location. that he targeted one or more of the people in there. Now, that could be because he has a relationship or a past relationship with one or more of them, or it could be that he's been stalking one or more of them. Asked later about the suspicion that the killer knew his victims, Clemente explained that the offender entered a home in the middle of the night when when anybody living there could have had a gun. Multiple people could confront and attack him when he got in, unless he knew them, unless he knew one or more of them. I think that reduces the risk if he did, or if he was stalking them and he knew that on the weekends they all got wasted and they went to bed early, or they went to bed in the early morning hours and they didn't get up until late afternoon because they were all wasted. He added, so if he knew their routine and he knew they were all drunk, then that again reduces the risk factor to this offender. So making this a more plausible crime to commit. So just the fact that he got away with it in that time. When asked why he believed the suspect was a male, Clemente pointed to the defensive wounds that some of the victims allegedly had. They fought back. This is somebody that was able to kill more people, including a male victim, Clemente said. He also referenced the use of a knife as a murder weapon and said, such violence is more indicative of a male offender. He said the time of the attack during the late night, early morning hours shows that he has the freedom of movement during that time. He is not in a relationship or a job that would keep him from committing the crimes during that time. Moscow police received a call shortly before noon on November 13th for a report of an unconscious person at the King Road home, and several other people had gathered at the address by the time police arrived, officials said. The victims were slain in the second and third floors of their home between 3 and 4 a.m. on November the 13th after they spent the night out. The victims were identified as Ethan Chapin, 20, of Conway, Washington, Madison Mogan, 21, of Coeur d'Alene, Idaho, Xana Kernodle, 20, of Avondale, Arizona, and Kaylee Concalves, 21, of Rathdrum, Idaho. Kaylee and Madison were best friends. 2 other roommates were inside the home on the bottom floor at the time of the murder, but were uninjured. The victims all believed to have been asleep when they were attacked, though some showed signs of defensive wounds. Each victim was stabbed several times and showed no signs that they were sexually assaulted. They all believed to have been killed using a single knife. Clemente, who became a writer and producer for shows including Criminal Minds, said it was important to note that the killer chose a knife. Why did he choose a knife? Because it's quiet. It didn't wake up the rest of the residents in the house. And it could be for that reason. But Clemente said it could also be that the offender is known to carry a knife and might even show it off to his friends. The fact that he used a knife, Clemente explained, it's graphic, but we'll call it he doesn't mind wet work. He doesn't mind getting his hands dirty. He doesn't pale at the sight of blood. He said he believed this could mean that the suspect is a hunter, a butcher, or is otherwise in a field of that nature. He killed 4 different people this way. He didn't just sort of blanch and run after the first one. Examining the killer's behavior before and after the crimes, their pre- and post-offense behavior can be useful for the community and investigators working to solve the crime. Pre-offense behavior includes factors such as that the killer could have been proud of his knife and carried it around and showed it off to people. Also, that he had some kind of contact with or was fixated on one or more of the people in the house. As for his post-offense behavior, the suspect would have likely fled the area and won't come back until it calms down. At a time when so many people are leaving town for the holiday, such an absence might not be noticeable. But he may be local, and he may not have shown up for work or was late afterwards. And he probably has a very significant interest in the following of the news of this crime. Moscow Police Department officials are asking the public to share all outside surveillance video taken from 3 a.m. to 6 a.m. on Sunday, November 13th, 2022, from businesses and residences within a specific area. A manhunt continues for the person or persons involved in this attack, and police are asking anyone with information or footage related to the slayings to call 208-883-7180 or tip line at ci.moscow.id.us. I thought that was very telling. I also thought it was very telling for us in the Delphi case, because it gives us an idea when you get to hear a really renowned profiler talk about things that they look for. If Richard Allen did this crime and is bridge guy, he hid in plain sight for nearly 6 years. He went completely under the radar, which is absolutely bone-chillingly scary. And it says a lot about who he is. So, anyway, that's going to be it tonight, guys. I'm really tired and my voice is just about gone. And you guys have listened to me enough for one day. But I so appreciate you being here. I appreciate my new member, Verbal Judo. Thank you so much for joining and for supporting me. I appreciate that so very, very much. Hey, Cindy Delafuente. How are you, my dear? So good to see you. Ted Bundy was cringeworthy as a killer. He was well-spoken. He was very educated, very well-dressed, very well-mannered. People described him as kind. He took phone calls on a suicide hotline, for God's sake. He was personable, easy to talk to. So you have to remember that when you're talking about these types of killers and these types of people and who they can be and how they can present themselves. I hope everyone has a wonderful Thanksgiving. For all of my subscribers and supporters and members that are not in the United States and aren't celebrating Thanksgiving, I hope you all have a great weekend. Go do something fun. And I will see you guys all next week on Tuesday. And no, Heather, they've never released a profile for Delphi. Partial. They released a partial profile. They said to look for things like people who changed their appearance, or people who started using alcohol or drugs, or people who missed an appointment, or were late for work, or lost their jobs, or all of that kind of stuff. They never really truly gave us a profile. I will tell you, Richard Allen has certainly changed his appearance multiple times since 2017. He is not the same guy that he was back then, by any sense of the word. Happy Thanksgiving, Deb. Thank you so much for being here. Let's see. Who all are my tech deaf? Thank you so much. Jennifer, thank you for hanging out. Thanks for all of my mods who were able to hang in there with me tonight. Thank the Lord we didn't have too many trolls tonight. Thank you so much. And I appreciate each and every one of you. Go enjoy your families, and we will talk soon. Have a great evening, everyone. Good night.